everyone. I'd like to welcome you to Trademark Abilities Insider. My name is Stacey Calamaris, and I'm a trademark attorney and the lead instructor at Trademark Abilities. Trademark Abilities is a comprehensive online training academy for lawyers interested in learning the practical aspects of practicing trademark law at the USPTO and becoming confident trademark practitioners. Through our signature masterclass, we provide the practical and strategic learning necessary to set up a trademark practice so that lawyers can competently and effectively represent clients before the USPTO. Our templates and other resources have been described by our attorneys as a trademark practice in a box. I want to welcome you, Emil, to Trademark Abilities Insider. Through this series, it is my intention to interview people like you who have insider knowledge that help make the life of the trademark practitioner a little bit easier. And with that, I'd like to turn it over to you to please tell us a little bit about yourself.
Thank you, Stacey. It's a pleasure to be here. I'd like to introduce myself. My name is Emil Ali. I'm a partner at McCabe Ali LLP. And I focus most of my practice on representing attorneys and law firms in all aspects of ethics and professional responsibility matters with a heightened focus towards IP practitioners. So I am a registered patent attorney, and I kind of started this sort of area of my career by working within the USPTO's Office of Enrollment and Discipline, which is essentially the bar counsel slash registrar slash the police for patent and trademark attorneys. And since our conversation today is going to be focused on trademark attorneys, I'll kind of start out by saying that a lot of folks don't know it, and I'll kind of describe a little bit more later on with what OED is, but even though you might be licensed by state bar, you are also regulated in the practice before the USPTO and trademark matters by OED. So, my job when I was at OED was to investigate allegations of misconduct, everything from the normal, stealing from clients to, things like not signing a document properly or engaging in UPL, unauthorized practice of law. And now on the other side, as I call it, I like to help these practitioners. So, when they get an investigation issued by the OED, I help them respond to it, hopefully help them, steer away from trouble. But I also help lawyers and law firms transition, help them resolve disputes with their law firms, or the law firm to resolve a dispute with the former attorney, deal with, transitioning, so lateral movements, and of course, helping understand things like conflicts of interest, problem clients, and if needed, obviously defend them in ethics and malpractice matters.
No, I mean, I think it's such an important area, and you and I have known each other only for a brief period of time, but you have personally helped me in my practice, and it's one of the reasons why I really wanted to have you on. I mean, I've seen you speak a number of times, and it's just been so helpful. And I think that you highlighted a number of important things that I really do want to get into a little bit more. It wasn't until I was practicing for a number of years, I actually don't remember how many, that I realized that there were ethics rules at the USPTO that also applied to me. I knew that as a registered patent attorney, there were certain rules that applied on that side of the office. But I wondered if you could just explain a little bit more to our audience, who hopefully are trademark attorneys, what the ethics rules are and how they apply to trademark attorneys, and maybe if people aren't aware, where they can find them so that they can educate themselves a little bit more about them.
Sure, that's a great question. So I guess I'll start out by saying, and again, I don't want to get too professorial in terms of going back to, hey, here's the history, but the USPTO is one of the few federal agencies that has the ability to prevent people from practicing a certain area of the law, and that's patent law, based upon specific qualifications. So in order to become a registered patent attorney or agent, which is a whole different conversation, you need to pass an exam, be of good moral character, et cetera. Everyone else generally falls under the Administrative Procedure Act, 5 USC 500 et sec, basically allows you as an attorney licensed in any state to practice before any federal agency, and state includes territories, by the way. So I'm licensed in multiple jurisdictions, including DC, but let's just say I was not licensed in DC. Even though the SEC is headquartered in DC, I can still practice before it with a California bar license, a New York bar, whatever license I might have. But because we needed that because previously the rule said, oh, well, you probably need to have a DC bar license. That's where the Administrative Procedure Act really helped kind of make the playing field a little bit more level for people that were out of state. So with that, the agencies had the ability to allow anyone to practice for them, but still had the authority to regulate conduct. So the USPTO is one agency, but the SEC, Social Security Administration, all these different agencies, EOIR, so immigration lawyers, everyone has their own regulatory structure. Some folks or some agencies tend to discipline folks that come before them more often than others. And I would say the USPTO, I wouldn't say they are aggressive about disciplining people, but there's just a lot of practitioners, and we can kind of get into my personal opinion on this issue, but they're there. So where do you find the rules? Well, they're at 37, the Title 37 of the Code of Federal Regulations, and then Part 11. So generally speaking, if you're looking for any rules dealing with USPTO, you would normally go to Title 37 of the Code of Federal Regulations, and then Part 1 has a lot of information about patent matters and obviously some general matters. Part 2 generally deals with trademark matters, and Part 11 generally deals with the ethics rules. There's other parts as well, but those are the general ones that I refer to. And then obviously, as you've probably mentioned in one of your other videos, and obviously in your class, that the TMEP also has a lot of this information. So the TMEP actually incorporates a lot of the information from these rules. But you touched on kind of an issue, and maybe this has to do with your whole the framework. And I think what you're doing here in terms of educating trademark attorneys, I think is really important, because what I see in my practice is a lot of people tend to dabble, right? So a lot of my clients that I see on the trademark side are maybe a family law attorney, or they're a business attorney, and a client asks them about a trademark, and they said, of course I can handle that. That's just filling out a form.
Sure.
And yes, it is filling out a form, but what's the value add you're providing? Well, you're giving advice, right? You're advising them whether or not to get a search. You're interpreting the search results. You're prosecuting the trademark application. So responding to office actions, advising them what to do, advising them about disclaimers, helping them with their assignment. And that's the problem, is that, I mean, I will say this very open and notoriously, like, our legal education system is messed up, right? Because you're taught to think like a lawyer, but you're not taught how to be a lawyer. And it's sad, because yes, we want people to know how to file a trademark, but it's not easy. You can take a 1-hour CLE, but no one's going to walk you through the process. So how do you deal with that? Well, trial and error, right? That's one way. And trial and error is, you probably have a good percentage chance that, you may mess up, but you also have a good percentage chance that you'll do fine, and no harm, no foul. But, I think having the ability to take a course and spend a couple hours learning, walking through the practical aspects is invaluable, right? I wish that the bar required things like that.
Me too.
But I apologize.
Me too, Emil. Thank you.
Yeah,
Thank you for saying that.
But some people just put out their own shingle. And unfortunately, immigration, trademark, and criminal defense are, in my opinion, the 3 areas where people that put out their own shingle always navigate towards, because they think it's easy, right? And again, some parts of it are very simple, right? On the kind of threshold level. So filling out a form and saying, okay, well, this is the type of company organization, this is the name of the applicant. It could be, that's simplistic, right? However, here's something that, we probably recently saw on this listserv that I know you're also a member of. What happens if you put in the wrong entity, right? You can't assign the rights from a non-existent entity. And so those sorts of things happen when you're dabbling, or you're not paying attention, or even when somebody's doing a pro se mark, they don't understand. They don't understand use in commerce. They don't understand bona fide intent to use. And those are all very, very important issues to think of.
even drafting an ID can, there's an art to that, right?
Yep.
It's not so easy all of the times. In trademark abilities, we spend a lot of time focusing on the rules in the TMEP surrounding who should sign applications and the declarations in those applications, going through that language. And our advice always is that attorneys should not sign any documents. I know from listening to your presentations, certainly no documents that require firsthand knowledge in the application. I should amend my statement.
Yeah.
I know from your presentations that you share that perspective. Could you maybe speak a little bit to why? Because I still see very experienced trademark attorneys signing applications and statements of use and renewal forms, and it boggles my mind, quite frankly.
Sure. And I think there's a few reasons that you still see that. One is people don't know.
Yes.
2 is people don't know how to use the USPTO system, so it's easier for them to sign. And 3 is sometimes their client is uncomfortable signing because they just don't know the process, and they just say, I'm paying you to do it, you do it. So you're right that I do preach that. I say, try not to sign whenever possible. But I'm realistic, right? I know that it's just appropriate sometimes to sign. And I have signed, documents before as well. And I think the way that I like to put it into perspective is if you are dealing with a brand new client, and the client, and again, hopefully the person that's listening to this video, it understands a little bit about the basics of trademark law. So, when you're filing an application, which includes a statement that the mark is being used in commerce, it's a declaration under penalty of perjury, so under 18 U.S.C. 1001. So when Stacy signs an application and it says, yes, I'm affirming to the USPTO under penalty of perjury that this mark is actually being used by my client in commerce. This is a client that came in online, or maybe you met briefly that came as a referral, but you don't know them really from Adam, right? They're a friend of a friend. How are you going to verify they're actually using that in commerce? So first of all, many of my clients, and this is sometimes how they become clients, is they go through the process. They're like, oh yeah, I'm sure they're using it. It's not me making that representation. It's the client. I'm just signing on their behalf. That's why there's a problem, right? You are making the representation. It might be on behalf of the client, but it's you. So do you have a good faith basis to do so? And that's a complicated question, right? There's no rule that says, Stacy, you're in one state and your client's all the way in, another state or another country. Nothing says you need to fly over there and verify that, right? There's no bright line test. But how can you comfort yourself with an understanding that this mark is being used in commerce? So let's just take that a step back though. Why is this important? So you might say, well, it's not a big deal. They're probably using it, or maybe they will eventually use it. Who cares, right? Well, the USPTO cares, right? The USPTO is going to grant a mark and essentially give you a defendable position of priority in case there's litigation, or prevent somebody else from applying for it. Even somebody that's thinking about applying for it, going for a clearance search, they're going to see that mark, the application or the registration. So you want to be as accurate as possible. And then of course there's a penalty of perjury argument. So even if it's of no material issue, the fact that you made a statement is nonetheless important, right? You made a statement. It's like the USPTO considers itself under the rules, under the ethics rules, as a tribunal. So imagine if you made a statement in a brief in litigation about your client that turns out not to be true, right? That's still important, even though it may not be like, you might have said, well, what do you do about it? Well, you could probably, one, ask for more information, right? So that's the path that I would go through. I'd say, either one, I need to have the client sign it, or two, I need to ask for more information. But the question is, does the conversation end there? And that's where things get a little bit tricky. So let's just say you tell the client, I'm sorry, this is the beginning of our relationship, and I need to get some more information from you to make sure the mark is actually being used in commerce. Okay, you sent me the specimen, and we only need one specimen for the filing, but you have, like, let's just say 20 goods in the ID, and they're all related. So one thing you could do, if you want more information, you actually have a phone call with them, you ask them some questions, and ask for copies of all those specimens, right? That's probably a decent idea. You don't need to file all of them, but I think that would be a good idea. I mean, it shouldn't be a
I
lot of work.
always think that's a good idea.
Yes, yes. But then the other
Even if you're
option
not
is,
signing.
yeah, exactly. But the other option is, why don't we just have the client sign it? But does that resolve the issue?
No.
And yeah, the answer is no, exactly. And the reason is because, are you digging your head in the sand? So are you basically saying, let's just have the client sign it? You know what? I don't think that I don't think they're actually using it, but I don't want to make a false statement. Let me just let them make the
Right.
false statement,
You
right?
can't wash your hands of the issue by punting the ball to the client either.
Exactly, exactly. And people do believe that, but that's not something you can
Really?
do. Yeah. I mean, it's unfortunate because I think it goes down to not understanding the why, right? Practical education is super important. So yeah, so the bottom line is it's not a bright line like, oh, have your client sign it or have yourself sign it, but I would say a mix of, hey, let's ask for more copies of the specimens, counsel them, maybe come up with a form email saying, hey, thanks for asking this. You have a very large number of goods listed here, and the USPTO has a post-registration audit program that we want to be
Yes.
mindful of, but it might just be helpful for us to also have this to secure our mark, to make sure we have the most compliant mark that will be more difficult to challenge. And in doing so, I'd like to verify everything, because once there's an allegation of fraud, let's just say one mark was not, like one of the goods was not actually being used in commerce, that could weaken your entire mark and, blah, blah, blah. This would be helpful. And then, sometimes I can tell you this, my clients, some of them will say, you know what, Emil, I don't think I can do that. My clients are just going to walk away. Well, you know what? That's fine. If your client is not willing to spend the time to give you some more information to make their mark stronger, they might not be a client you want. And yes, they
I
might go to your
agree.
competitor.
I
Yeah.
agree with that. I mean, look, the declaration says that the mark is being used on all of the goods listed.
Yep.
So if you believe that your client is not using the mark in connection with all of the goods and services listed, there's a problem to begin with. And we're going to talk about this at the end because I want to get your perspective on some of the changes that are coming up with the Trademark Modernization Act coming online later this year. But if we don't do our jobs to counsel our clients with respect to what can happen later, to your point about maintenance and renewal, and now with the Trademark Modernization Act, if they have a huge laundry list of goods and services, first of all, no one needs a whole kitchen sink application. And when I'm counseling foreign clients, I always tell them, right, they come in through Madrid or something else, and then of course they get an office action because of the foreign counsel rule. I say to them, are you going to use all these things in the US? And they say, well, no, that's what the foreign application's based on. And I say, great, so let's cut it out now, and this is why. It can't just be one-way traffic.
Exactly.
It has to
Yeah.
be, back and forth. One of the things that you've really helped me with is sort of beyond the IP perspective and really understanding, helping to make my engagement letter stronger and really asking those questions of, is this a client you want to have? And so one of the things I wanted to ask you was some of your tips for what attorneys should be thinking about as they're engaging new clients, and who their client is. I know I recently had an issue that you helped me with where I have an individual who's a prolific inventor and also owns a number of trademarks, but there was also a number of entities involved. And so trying to figure out, well, who's the client? And how should we think about those things as we are engaging new clients?
Yeah, that's a really good point. So I like to think that the engagement letter / fee agreement / any sort of document that outlines your representation. So first of all, it's not always required, right? But it's always a good idea, right? So if you have a quick initial consult with somebody that you charge or don't charge for, yeah, you don't need an engagement letter. But the rule of thumb and the kind of the number in most states is if it's expected to cost over $1,000, it's highly suggested, or in some cases required, to have a fee agreement. And I think that's a pretty good rule of thumb. But it's always a good practice because even though attorneys have malpractice liability, it's always helpful to still have certain provisions in a contract that really outline what to do in the case of a problem, right? Because that's really what the engagement letter, I think, and again, when I use engagement letter, I also mean fee agreement, whatever. It really outlines, it's like a foundation, right? The building blocks of the relationship, right? It's going to tell them, what you're going to do for them, potentially how long it's going to take, maybe how or who you're going to communicate with, identify all these things, but also, if there's a problem, where's the arbitration going to be? What law is going to apply? Might also limit something by saying, well, I'm not licensed in these jurisdictions, even though I might, be doing something that could look like I'm, licensed. So all those things should be addressed or potentially addressed in an engagement letter. But, in terms of, if I had to list some of the major points that I like to think of as being important in an engagement letter, is who is the client, right? That's the issue that you just kind of talked about. Is it John, the, individual, or is it the company that John is founding? And why is that important, right? As you, as a trademark attorney, know, it's very important to list who's actually going to be the one with a bona fide intent to use, or that's actually using the mark in commerce. Listing the wrong person can be very problematic. But for purposes of the attorney-client relationship, are you representing the individual or the entity, right? And that's really important. And what happens if there's multiple people involved, right? Are you representing two people, or are you representing the company that they own? And what happens as well if there's a problem between the two of them, right? Those are all very important issues
Really
to think
important,
about.
yeah.
But who is the client, right? Then the what? What services are you providing? And then, are you limiting the scope of the representation, right? That's really important, like a 1.2 issue. So are you, for example, just filing a trademark? Are you just doing a search and opinion? Or are you filing a trademark and prosecuting it? Okay, well, let's just say that you get them a trademark. Who's responsible for renewals, right? This is a very important consideration. It's actually very important, especially on the patent side too, but on the trademark side as well. When the renewal comes up, what happens if you're not in business, right? You could still get sued. What happens if you changed offices and changed your email address and you didn't get the correspondence from the USPTO? Those are really important issues. So, talking about the scope is really important. And then even if, it's a limited scope, what happens to the client file when you're done with the representation, right? That's important. Do you keep the client file for a year, for 10 years, et cetera? The hourly rate, or is it a flat fee? But let's just say it's a flat fee of $500 to file a trademark application, okay? Limited scope. Did you include something in there about how much you charge per hour to prosecute it if they decide to extend that fee agreement to other matters, right? Those are really, really important things to think of. But beyond that, there's the other issues with maybe an advance waiver if needed. Those can be problematic, but maybe there's a third party paying legal fees. So what happens if maybe a venture capital firm is paying their fees, right? That's an issue under Rule 1.8 of the ABA model rules in many other states, and then 37 CFR 11.108 of the USPTO rules. I know it sounds funny, but when somebody other than the client is paying for the fee, you actually need to get the informed consent of the client to do so. And it's also helpful to get an understanding from the payor that they're not your client, right? They might be paying the bill, but they don't have a right to know what's going on in the matter unless it has to do with the representation and the client has given consent to do so. So, the engagement letter really sets the foundation. And then on the other side of that, what happens when you're done? The question is, in my mind, do you close out the matter? For some industries, it's not as important. For trademark law, it can be important, because if you represented somebody 5 years ago in a trademark matter, and now there's a potentially competing matter that you want to file a mark for, you might be able to do it, but you can't do it if they're a current client. You might be able to do it if they're a former client and you're still complying with your Rule 1.6 obligations. But the question is, how do you know and how do they know they're a former client, right? Did you send them what's called a disengagement letter or a non-engagement letter? Same thing if they're just a client that called you up and never actually engaged you, right? It's just helpful to communicate, right? A lot of what I see problems that come up, and like a lot of what I do is not only disciplinary, right? It's just advising people. So like a lot of times clients will come and say, hey, Emil, I have this client that's really mad at us and wants a refund. Can you deal with it? And I'm like, I can, but why not just pick up the phone and apologize for the miscommunication, and maybe throw them a small discount, but don't give them the whole thing. And usually, like 9 times out of 10, the matter goes away, right? But when you double down and say, no, I did everything correctly and you're wrong and I'm never giving a refund, where does that go? It goes to the state bar and or to OED. And then the only thing that happens is your insurance rates go up and I end up billing you for dealing with that complaint. So there's a lot of, like, it's kind of like the ounce of prevention analogy, right? I mean, that's really, really important. So.
Yeah, no, that makes a lot of sense. That makes a lot of sense. We're getting a little short on time. And so I do want to address, because I know that the comment period for the Trademark Modernization Act has been open, and I don't know if you've had a chance yet to go through it, but have you seen anything in the USPTO's proposed rulemaking for the Trademark Modernization Act that gives you some concern or things you want us to be aware of, especially from an ethics standpoint? I know that there is a proposed rulemaking where the sort of, if I have this right, please correct me if I'm wrong, the automatic kind of termination of representation when a mark registers is now going to be changing. I saw something about that, but I don't have all the specifics. So I wonder if maybe you could speak to that and anything else that you've seen from an ethics standpoint.
Sure. So it's a little bit of an interesting rule package that came out. I believe the comment period, I don't recall offhand, but it might be July 13th or somewhere
like
around that.
It's mid-July sometime.
Yeah. So here's the issue. So I'm not going to talk about the substantive trademark rules. I want to talk about really what they call attorney recognition. So currently, if you're an attorney and you have filed a power of attorney in a trademark application, if it's live, you're the attorney of record. If it abandons or if it registers, the TMEP, the Trademark Manual of Examining Procedure, basically says that and the rules, the regulations, they say that your recognition, the power of attorney, essentially expires upon registration. What does that mean? That's debatable. I think I've argued it both ways. So from a substantive trademark law perspective, it means that the USPTO does not recognize an active, attorney, recognition or kind of power of attorney, but they would still send correspondence to the attorney of record because they're the correspondent. It generally means that for all intents and purposes, you might have terminated the representation, but you don't really need to withdraw from the representation like you would in court because it has expired. The problem is that many people don't realize that you might still get mailed correspondence. And if you do, you need to forward it to your client. So there's an ethics obligation that kind of trumps the recognition argument. So at the end of the day, what the USPTO proposes to do is do away with the automatic termination of the recognition. So you would have to affirmatively, once the final rule passes, withdraw from an abandoned mark or a registered mark. Well, let's forget the abandoned mark because that's not super important.
Right.
But from a registered mark, that could be just a good idea because you don't want to get correspondence sent to you if you're no longer representing them, because then you have to keep corresponding with them. You'd say, hey, sorry, we don't represent you anymore, but wanted to let you know about this. But people can always get confused. And as you probably know, the attorney-client relationship, yes, it can be, made by virtue of signing an engagement letter, but it could also be inferred from the circumstances, and it's based on a reasonable kind of person test based upon what that client thinks. And so, you want to avoid having that. So withdrawing is probably appropriate. So the saving grace, though, is that if the rule package does get adopted as final, they propose to have a transition period where, for example, if you're currently active on 100 registered marks, they're not automatically going to remove you as attorney of record because they're going to say, well, it could be that Stacy is still representing them, but hasn't withdrawn because she's still representing them. So they'll continue to send you correspondence, but they'll make the power of attorney expire. And then you just have to, next time you file, just affirmatively state that you're still the attorney of record. So I think it's a really interesting rule. I had, some misgivings about it at the beginning. I was like, it's going to be more problematic because, like, for example, if I had a client that was being disciplined, if the power of attorney is expired, I would say that you don't need to notify that client of your discipline because they're not really your client because the power of attorney has ended. But, on the whole, I do think this change is better because it really aligns it to the patent side. It really aligns it to the ethics rules. So I think it's, it may be a change in thought, but in reality, it's no change at all. It's basically, it would be my recommendation still for most people. If you had a limited scope engagement to get somebody to the registration, withdraw afterwards, unless you plan on offering them other services. But
Right.
one thing I'll note again is that docketing is very important. And, do you want to be on the hook for that? And like what I would tell people is whenever possible in your engagement letter or in your reporting letter after the registration, say, we do not monitor your renewal. You will receive this correspondence. And in reality, you can send them a reminder email. You can still docket it, but tell them that they're responsible for doing so and make sure that they're the correspondent. A lot of people say, well, that means they might do it themselves. Well, yes, that's always possible. They can do it themselves. It's also possible that they'll get a scam mailer or a mailer from your competition. But in reality, I think it's, you really want to balance the faith you have in your docketing system with the potential liability there.
We never promise that we will remind them definitively of a maintenance or renewal reminder. Right? You have no idea what firm you'll be at. You have no idea if your existing firm, if you're a solo practitioner or a small firm, will still be in existence. We always impress upon the client that it's a very important date. They should note it in their calendar that they're responsible for it. And that's the purpose of the registration reporting letter. Obviously, if there's an opportunity to remind them 5-6 years down the road, we want every opportunity to do that. I like the proposed rule also because I think it's in line with the USPTO's sort of new guidance in having someone always to alert for board proceedings. And I think it just will help the office a little bit in having someone of record to sort of serve opposition and cancellations. And with the new expungement proceedings coming online, I think it'll just make things a little bit easier for all of us, right, to be notified of those proceedings. So I think, it sounds like maybe one little teeny tiny extra step, but I think it potentially, once we all get used to it, won't be that big of an inconvenience. So
exactly,
interesting.
Yeah. And I know we're running out of time, but I'll just say one last thing I want to highlight. You kind of mentioned, we might not be at the same firm, and this is where I feel like a lot of practitioners, not just trademark attorneys, patent attorneys, a lot of attorneys don't realize that you, the individual, have an attorney-client relationship with the client, right? Your firm may have a contract with them that lays out that relationship, but there's a really good ABA opinion that kind of deals with transitioning attorneys. And it's really important. Firms always give you a hard time, or not always, many, and I'd say it's usually smaller. Yeah, smaller firms tend to give, big firms are wised up to this. And, you don't want to put your profits before the ethics rules, because at the end of the day, if you're departing from a law firm, and if you have a substantial relationship with a client. So the way I try to describe it is, if you write a memo for your partner or whatever, let's just say you're an associate, you write a memo for your partner and it talks about, or like you analyze the search report, the client never sees it, or the client sees like one email from you. Yeah, you probably don't have a substantial relationship. But if you do all the trademark work and you're moving from one firm to another, you need to let them know you're leaving.
Yes.
But you don't just say bye-bye, right? You say, I'm attorney of record, you have a couple options here. I can withdraw and somebody else can take over, or you can move with me to my new firm. So your old firm's like, no, you can't say that. They're our clients. Nope.
No,
they
it's
are
client's
not your
choice.
client.
Always.
Client's choice. Always client's choice to leave. And I think that's one area where I just spend a lot of time when I represent these folks, just educating a law firm. And they're like, no, you're wrong. And I'm like, well, here's a bunch of ethics rules. Here's a bunch of cases. And, we don't want to take this to any sort of bar proceeding, but this is unethical for you to restrict my client's right to practice. And
clients aren't books in libraries.
Exactly,
they're capable of making their own choice.
Exactly. And it's funny because for doctors, they are allowed to have non-competes and non-solicits, and I think that's just strange, because I would say doctors and lawyers, it's such a personal relationship that and I'll just tell you a quick story. I had a friend of mine that's a trademark attorney, helped her get a job with a friend of mine. And she expected to bring in a very small book of business. And she's like, Emil, I don't really have a, and I was like, okay, well, don't forget to tell all your clients you're leaving. I'm sure some of them will come with you. She's like, but they're not my clients. They're the firm's clients. And I was like, no. And I was like, let me help you. And I gave her a sample letter. And I think it turned out like she expected to bring in something like less than $50,000 worth of business. She walked away with like $300,000 in recurring revenue.
I
And it was
love
great
it.
because it was really nice person and
That's a
ended up with
wonderful
a
story.
really good experience. And, it was just like, she got to surprise her new firm. They already thought she was a superstar and now surprised them with a book of business that just made her more successful and kind of on that track to partnership. So.
What a fantastic story. I can't thank you enough for sharing your insider perspective. I thank you so much for being so generous with your time.
Of course. Take care.